Hi, I'm Michelle. Welcome back to Finally Revealed. In this video, I want to talk today about mediation. Mediation has really come into the forefront in legal disputes in recent years, maybe 10-15 years, primarily in the area of domestic relations. Mediation is used by parties to a divorce most often in order to arrive at an agreeable visitation schedule with children, or to agree upon a division of assets in the event of a divorce. Mediation, however, can also be used and is used in collective bargaining agreements, in employment disputes, and in a whole host of business type areas. It can also be entered into between two individuals who have some type of a dispute and they don't want to sue each other or go to court and expend the extra expenses of an attorney, although mediation often does involve attorneys, or involve a prolonged court process that they don't have as much control over. Now, every lawyer that you talk to, if they're being honest, they will tell you that it's better for you to resolve your own dispute than to turn it over either to a judge or a jury. And this is keeping in mind that both parties are motivated to reach a resolution and that they want to continue on their particular relationship. If one side or the other is not invested and is no longer interested in maintaining any type of relationship, then mediation is not necessarily going to give you the result that you want. It might be harder. And that is because of the inherent nature of a mediation. How a mediation works is there's a mediator, which is one person who is agreed to by one or more sides. A mediation doesn't have to just be between two sides. I had a case where we went to mediation and there were about 5 sides. We had a great mediator. That is not a common occurrence, but it can happen where you have multiple sides, and you have to have a very strong mediator in order to keep everything straight and to keep things moving along. How the mediation occurs in a broad stroke is that the parties get together at a time and a place. Typically, if it's court ordered, you have to be there, or a representative, somebody with authority, either has to be in the room or has to be available by some type of technology in the event that there's information needed or a deal is reached. The mediator will have an agreement in advance for fees to be paid and how much those fees will be and when the mediation will occur. They will also have an agreement that what happens in this mediation is not going to be capable of being discussed in a court of law. It's going to be confidential. The one exception to that is if you have a mediation where an agreement is reached and then one party decides to forget about the agreement or ignore it. I've had that happen. We had to go to court and enforce it. And at that point, obviously, what happened in the mediation was very important to that case. So the mediator has the agreement in advance. You have a set date, time, and place. You appear. The mediator makes a speech, kind of gives people the parameters of what physically is going to happen, where people are going to be located, and how that mediator likes to work. The general framework is the same every time. The mediator tells people about uncertainties of litigation, about the importance or the desirability of making an agreement that you can live with, that you know about, that you intentionally make. They will also often say that a good resolution is one where neither party is completely happy. Okay, so if everybody's a little unhappy, but you've come to something that you can do, you can live with, then that's considered to be successful. The parties may or may not, well, in advance they will have presented information, particularly if an attorney's involved, they will have presented information to the mediator in advance, some that can be shared with the other side, some that cannot. Sometimes the mediator will ask, what are your parameters if there's money involved? What can you do? What is the leeway that you have? What's your authority? And that will not be shared with the other side. Then the mediator meets with one side or the other to answer questions about what they might have received in advance and get a flavor for the situation. Then they'll go to the other side. Then they'll start taking offers and terms back and forth. One thing that you should keep in mind, and this is something that some of my clients have had a hard time with, I have to remind them, the mediation is not an informal trial of your problem. That's not the goal. The mediator is standing in the middle, trying to figure out how to move the parties closer together. The mediator really doesn't care how it resolves, but the mediator is looking for information from each side about the other, but about themselves, in order to maneuver the parties closer together. If there is a resolution, they will have a term sheet, and they ask for this if they don't offer it, a term sheet to identify what the basic points are, because everything will have to be drawn up into a more formal and protective agreement. But the basic terms and deadlines, you want to get deadlines as to when different things will happen, in particular when the first draft will come out and when you can have this signed by. And then both parties will sign it and then go their separate ways. You won't always be able to resolve everything in the mediation, but you may be able to get one or two major points out of the way. For example, in a divorce case, that will save you time and money later and give you some certainty, and then kind of diffuse some of those other arguments and let you focus more on other issues. It's a good tool when used properly. It can also give you an idea as to the relative strength or weakness of your particular case, and hopefully it will help you to get a result that you can live with. I hope this is helpful to you. If you like this video, let us know by liking, subscribing, sharing, and for other videos, you can follow us on Twitter or Facebook at FinelyRevealed. Thanks, and I'll see you next time.